I'm happy to announce the opening dialogue, Current Reflections on the UN Agenda 2030. This panel will focus on the key elements of the agenda, and it's going to be chaired by Dr. Nora Arajervi. She is an associate at the Hertie School of Governance, and she is an international lawyer. Currently, she works as a consultant for the Center for Social Legal Studies at the University of Oxford. Dr. Arajervi, please.
Thank you. Good morning, and thank you for inviting me to chair this opening dialogue with Sam Müller and Betty Kari Murungi, who I will introduce in more detail in a few minutes. Now, this is a very timely topic we are discussing here today and tomorrow. It's a chance to reflect on the challenges and calls for reform of the international criminal justice system, not least within the ICC, and the synergies they bear to holistic approach to sustainable development. On the other hand, the UN High-Level Political Forum on SDGs this summer is the first time that the SDG 16 will be a priority area and a central focus of the voluntary national reviews. This will be an unprecedented opportunity for states to show their progress in promoting peace, justice, and strong institutions. This morning, our opening dialogue will introduce and critically reflect on the UN Agenda 2030, the SDGs and their relation to the field of international criminal law. Although the core discussions of the conference will center around SDG 16, which strives to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. It is also important to reflect on the objectives of the agenda as a whole, as well as the relevant human rights targets that can be found under other goals. The opening dialogue will create the basis and foundation for the analysis that will be then undertaken by the panels during the next 2 days. For this reason, the dialogue will focus on one of the most important aspects of the UN agenda, the creation of voluntary review mechanisms for states and the impact on governmental decision-making processes, among other issues we'll discuss. The objective of the mechanisms is to conduct regular and inclusive reviews of progress at the national and subnational levels, which are country-led and country-driven. Now, currently the commitment of states to present national reviews has been honored by altogether 102 countries, which have presented 111 voluntary national reviews. It's anticipated that 51 countries will present VNRs in 2019, and this includes the assessment of the SDG 16. Also, these voluntary national reviews, with the purpose of sharing lessons from the experiences of each national program, are extremely useful tool to develop a coordinated action for the implementation of the 2030 agenda. For the creation of a strategic action towards the objectives, it's fundamental to have the right information to define public policies that guide the different stakeholders into the same necessary direction. The 17 Sustainable Development Goals have altogether 169 targets. They are supported and measured by 230 indicators which have been identified by the Interagency Expert Group on SDGs. And they measure the progress of each target, providing a universal framework for the collection of data. Until recently, the coverage and assessment of comparable statistical information was difficult, making it complex for international organizations and states to evaluate the real situation in many countries. While the MDGs contained substantively narrower focus with fewer indicators, this new indicator framework draws from a range of existing measuring tools, such as those created by the World Bank and multiple non-governmental organizations. With the adoption of the UN Agenda 2030, a new tool has been put in place for the creation of informed strategies with the objective to have peace and prosperity for people and the planet, and to promote human rights and leave no one behind. In the past decades, the proliferation of international treaties, conventions, and resolutions has contributed to the expansion and promotion of the scope for the protection of human rights and further increased access to justice for persons affected by conflicts. As it will be emphasized by the deliberations of the panels, the system of international criminal justice shares many foundational objectives with the field of human rights. Various ICL institutions have mandates that are related to or rely on the work of human rights monitoring mechanisms and commissions. The UN Agenda is conscious of these shared objectives and has included elements that aim to build peaceful societies, provide justice, strengthen the rule of law, help the reconstruction of affected societies, and promote accountability. Taking into consideration its genesis and state of implementation, this opening dialogue will further provide inputs regarding the current discussion about the evolution and future of the 2030 Agenda. Now, let me introduce the speakers of the opening dialogue. Betty-Kari Murungi is a member of the Advisory Council of the International Nuremberg Principles Academy. She's a lawyer with 30 years of experience in the practice of law on various levels and 10 years of experience in the management and governance of non-governmental and non-profit organizations. She was educated at the University of Nairobi and the Kenya School of Law, spending a year as a visiting fellow at the Harvard Law School's Human Rights Program, researching transitional justice mechanisms. She has broad experience in transitional justice processes, women's rights, constitutionalism, and governance. She co-founded the Urgent Action Fund Africa, served as vice chairperson and commissioner to the Kenya Truth, Justice, and Reconciliation Commission, and as the Africa representative on the board of directors of the Trust Fund for Victims at the ICC. Ms. Murungi served as the Senior Transitional Justice Advisor to the Joint Monitoring and Evaluation Commission in South Sudan. Recently, she served as member of the Independent Commission of Inquiry for the Occupied Palestinian Territory, appointed by the UN Human Rights Council. Dr. Sam Müller is the founding director and chief executive officer of the Hague Institute for Innovation of Law. An international lawyer by training, he works on justice strategy, innovation, connecting knowledge about needs and what works with justice change processes that make a difference. The clients he has worked for include governments, international businesses, and leading civil society organizations. He also serves as executive director of the Justice Leadership Foundation and led the team that set up the Wildlife Justice Commission. Before his work at the Hague Institute, he was closely involved in setting up the ICC and worked for the UN Relief and Works Agency, the ICTY, and the Leiden University. He also holds a law degree and a doctorate from Leiden University and has published and spoken on various topics, focusing on legal trends and strategy, justice leadership, justice innovation, and international justice issues. He serves on various boards, including the Wildlife Justice Commission, the Hague Journal on the Rule of Law, the Hague Academic Coalition, the Hague Institute for Global Justice, and the Dr. Hendrik Müller Wadenlange Fund. He is active with the World Economic Forum, where he is now a member of the Global Future Council of Technology, Values and Policy. Now, without further ado, let me give the floor to Sam. Would you like me to start with some questions, or do you want to jump straight into a specific topic?
Well, we were handed some questions, so perhaps I should firstly, I think it's a basic human right not to have to sit and listen to somebody read your own bio. Very, 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 very challenging thing to have to undergo. Yeah, well, what I could do, I mean, this is a dialogue, the first question we were given, would you like us to take that?
Sure, and actually now that I have the floor again, I will just make a quick point of noting that we will take questions at the end of the dialogue, but we also agreed that we welcome your participation as we go along to have this dialogue as interactive as possible. But I would remind everyone that please be very concise and limit your question or comment to 3 minutes. Now, let me see if we have the same questions there. I think the first one concerns the Universal Declaration, if I'm not mistaken. Yes. So in the journey of the field of human rights, since the adoption of the Universal Declaration, what do you see as the key progressions and regressions that have led to the current state of the field?
Well, first, perhaps I should say that what I'm going to, I mean, this is a dialogue, so what I'm going to say is probably not going to be all that coherent, and it's probably not all extremely well thought through, and that's because what we are doing, exploring the SDGs, how that relates to justice, connecting that to ICL, it's all pretty new stuff as far as I'm concerned, and I don't think there are a lot of, very well thought through concepts and ideas. So I see this very much as a learning conversation where I contribute some of the things that I happen to have seen and my own biases, and hopefully in a dialogue we can do what you say, lay a basis for the rest of the panels. Yeah, the question whether there have been progressions or regressions in the field of human rights is a pretty big one. And the first thing that came to mind when I read this question is that I have an increasing annoyance about fields, so the human rights field, the ICL field. Lawyers just love fields, because if you have a field, you have a specialization, you have a profession. And I remember when we started out with the tribunals, ICL didn't even exist, David. And it's now a field, aren't we proud it's a field? But of course there's also a big difficulty with fields, because fields create silos. So on the one hand they're good, because they create structures, they create concepts, shared concepts which you could work on. But the Sustainable Development Goals and human rights and what we're trying to do really are about outcomes in the real world, and fitting fields to that is always a bit difficult. And that's something that when you read, I think there are 3 reports that I find are very important for us all to kind of know about when we're thinking about this. And one is the World Development Report 2011, which is about security and justice. It's really excellent. It's one of the better studies that I've ever read, very empirical, solid on conflict, security, and rule of law. The second one is WDR 2017 on law and the governance, which I think is also really good. And the third one is the Pathways for Peace document, where from what I hear, miraculously the World Bank and the UN got together and actually started thinking, how easy or difficult is it to climb out of violence, and what creates violence, and what's prevention. And when you read WDDR 2011, when you read 2017, when you read Pathways for Peace, there are no fields. It's a continuum. The pathways idea in the Pathways for Peace is about pathways. So that would be one thing. But then when I look at the human rights field, and generally at the human rights field, I know there are a couple of observations, but I cannot say that I'm a deep expert. But my general impressions are that first, I think we've been able to weave, a fairly good blanket with fairly strong threads of treaties and laws that relate to human rights over the last 50, 60 years. So that's good. There are standards, and standards that people can invoke and that are being invoked. We've got a lot of awareness about human rights, so that blanket is kind of there. The blanket covers most of the world, and I guess that's progress. Whether that blanket actually touches each country, or whether it kind of hovers way above and therefore doesn't provide much warmth, that's probably doesn't cover a lot of countries yet. So it's there, but it's quite often high above quite a few countries. We have some enforcement mechanisms that we've been able to develop, some limited enforcement at the international level, some fairly functional stuff in Europe, the European Convention and things like that. There's some fairly functional stuff in Latin America. Some promising, but perhaps less functional developments in Africa. Not all that much in Asia, as far as I can assess. And at the national level, probably true to say that enforcement of human rights there is mostly happening in countries where the rule of law is already strong. And in some countries, it's actually, where it was strong, it's becoming less strong. And in countries where there really wasn't much rule of law, there still isn't all that much rule of law, and you can, as a government or as a business or other organization, still get away with a lot of human rights violations. Navi, you mentioned it. I find the development of social economic rights very, very interesting and important. But at the same time, they are proving to be hard to enforce. But they are, I think, very important. The internet and information technology has brought a lot of promise and a lot of good, but it also seems to be saddling us up with a lot of questions and a lot of human rights issues, privacy issues. I heard a TED talk last week where somebody was talking about Facebook as a crime scene to which we have no access. And this particular person was referring to serious electoral fraud committed in the UK around Brexit, and so that's really new and worrying. Spreading hatred, you mentioned that already, Navi. So I think on that side, there's a lot of very troubling things. The amount of people that are forcibly moving around has gone up tremendously. That's really scary, I find. In the UNHCR, 68.5 million people have been forced from their homes at the moment. That's higher than ever before. Quasi-democratic authoritarianism seems to be on the rise, which is troubling. So on the whole, probably on the last decade, things are going down. And I'll end with something a bit provocative, but I once thought that the ICC and the tribunals were a great progression, and to be honest, I'm less sure now, looking at the impact and the outcomes. That doesn't mean that I think they are a regression, definitely not, but there's a question there. What are they really doing and achieving? Thank you. Oh, yeah, sorry.
Thank you, Sam. Now, following up on what you said, while staying within the in the first question on the Universal Declaration and where we've come since. I would like to add to the discussion the question of universality. So the inclusion of human rights and justice in the SDGs, in the 2030 agenda, do you see that as contributing to the universality of the agenda, which has been one of the critiques that MDGs face, that they were not truly universal? Where does human rights and justice fit within that discussion?
Good morning, everyone. And thank you, Nora and Sam. Let me just take a step back to 1948, when the Universal Declaration came about. At that particular time, there was a lack of universality because there were only 3 African countries in the room at the time. And this was Ethiopia, Egypt, and Liberia that voted yes. Oh, I forget, South Africa was in the room too, but they voted against the declaration. Navi, I'm looking at you. And so the focus very much in 1948 was really on individual rights. And whilst this was an important development, many societies, certainly many societies and communities from where I come from, and in fact even from Canada and Australia and New Zealand and others, had organized themselves in terms of community, and so therefore community rights to them made a lot of sense if it was going to be debated. Sam has mentioned the development of norms and standards and international accountability mechanisms, so I'll not repeat that in terms of getting to a situation where we have standards and norms that are universal. But we have seen the struggles in standard setting. And here I want to mention just 2 examples. One is on the standard setting as pertains to the rights of indigenous peoples. These are, community rights, rights of peoples. And this took a long time to actually get finalized, and I think in the 90s is when we got the UN Declaration on the Rights of Indigenous Peoples after many, many years of struggle, and these are important developments in terms of standard setting. The second example I want to give is on the rights of migrant workers, and this came about also in the 1990s. Running concomitant to the developments at the UN level, we have to talk about what's going on at the regional level. So whilst the UN is articulating policies and frameworks on, for example, the rights of migrant workers or the rights of indigenous peoples, the African Union is at the same time developing its own policies and its own instruments on migration policy. Like they've just articulated a new Africa Union migration policy framework for Africa that runs from 2018 to 2027. And so therefore these are all policies and frameworks that are running in tandem with the UN norms and frameworks. Just to say that, in my view, the UN 2030 agenda, much like the Africa Union 2063 agenda, is a political declaration. It's a political declaration. It is aspirational in the extreme. Both of these policies and both of these agenda weave together the existing frameworks and instruments that Sam has mentioned and that we all know have been weaved into the 2030 agenda. So in terms of universality and in terms of whether these instruments are binding globally, one has to look at how they're being also implemented or not implemented across the regions. And I think we will find later on in our discussions that we have seen moving targets, collapsing of indicators, whittling down on some of the earlier commitments made in some of the earlier instruments. For example, the standard setting around women's rights and women's participation in the Women, Peace and Security agenda, for example. We have 8 instruments since the year 2000 on women, peace and security, all of which consolidate earlier commitments in CEDAW and in other instruments that pertain to women's rights and gender equality, which is an important SDG, one of the SDGs. I just want to say something about justice, this justice being a central theme that cuts across all the 17 SDGs. This, I think, is a laudable idea, and it is important. It's the first time, and we heard from Navi that the inclusion of human rights as in this 2030 agenda became very important. But I just want to remind us that actually Mongolia had developed their own 9th MDG on strengthening human rights and fostering democratic governance as a precondition for the achievement of the earlier MDGs, which then were 8, but they had developed a 9th MDG. And so therefore I don't know whether is Mongolia a small country, but a country such as Mongolia had already perceived that it would have been impossible to achieve any of the MDGs, the earlier development goals, without putting human rights at the center of all of them. And so it's not entirely surprising that justice is a cross-cutting theme in all the 17 MDGs, as it should be, but it is also the most, I think, observed in breach in terms of how we are seeing the development and the implementation of the 2030 agenda across quite a few regions in the world, and certainly across my own region, where we are seeing major reversals in the observance of human rights, in the development of democratic institutions. In fact, we are seeing a weakening of democratic institutions, and later on I'll be able to give a couple of examples about why I think why that is so unhelpful in terms of us getting to achieve universality in implementing the SDGs.
Thank you, Betty. Now, both of you mentioned briefly refugees and IDPs, internally displaced persons, and it was quite interesting during the negotiations at the UN of the Open Working Group on Sustainable Development Goals that this was quite a heated topic, and it was at one point included as a draft target under the SDG 16. But the wording was something along the lines to reduce the number of refugees and IDPs, which of course reads as quite a perverse initiative if it doesn't include any further qualifiers for the states on how to reduce the numbers. I mean, you can just close your borders and you reduce the numbers. So I think it was down to really this language issue there that it was dropped out about midway through the Open Working Group negotiations. Now going to what you said about standards and moving targets, how do you see that the 2030 agenda can help to develop a coordinated strategic action between different stakeholders in terms of formulating informed public policies for achieving sustainable development and the targets?
I was thinking about this last night, and I suddenly a tweet popped up on my phone from Amina Mohammed, who said, something along the lines, the first line was the SDGs are interrelated, and then she had a picture of SDG 16. And I think that's a really important thing to keep in mind to start with, that they are all interrelated. So that goes back to this field thing, and earlier this week I moderated a panel which had one of the vice presidents of the World Bank, the General Counsel, and this panel was about cross-sectoral collaboration. And the reason why they had this panel at the World Justice Forum is because we're all kind of realizing we don't really have a lot of good structures or experience on how to do cross-sectoral collaboration in a good way. How do you bring different fields together? How do you get them to talk in safe spaces where they can share things that work, things that don't work, etc. If you're interested, you can go back to the tweets of that panel under the World Justice Forum. And we came up with 7 habits, I think, of doing that. But I think that needs a lot more thinking, and that's where I see, and I think that's critical to make it work, and I see a little more innovation there in the non-state actor field than I do in the formal institutions. And somehow I feel the formal institutions have to come on board with this as well. And what was really interesting in around the Justice Task Force work, which we'll hear more about later, the World Justice Project, the OECD, the World Bank, Hill, we're all in the same room as equals, and we're all somehow contributing. And to me, that's a pretty unique experience where, and there's even a couple of big law firms, part of the discussion. So it's very diverse. It's also sometimes very disorganized. It's sometimes very confusing. But that is, I think, one element. The second element is, for me, is data. And that's something that is very clear in the SDG agenda. There's this paragraph saying that the follow-up and review will be done on the basis of, and I quote, rigorous, the follow-up and review will be rigorous, based on evidence, informed by country-led evaluations and data, which is high quality, accessible, timely, reliable, and a couple of other things. But data is really put at the heart of the SDG agenda. And that's where I think the justice sector broadly, is in serious trouble because we have very little data. At best, we have data on outputs, how many judges per square centimeter, how many decisions per day, how much we spend on lawyers, how much we spend on legal aid. But unlike the health sector, the education sector, there is hardly any data, only in few countries, on outcomes. What is what we're doing producing? And that, to me, is the revolution that we really all have to go for now, is data on a couple of things. First, the needs and the problems. So when you talk about SDG 16, when you talk about, for example, an area that I've been working on a lot, access to justice, what do we know about how many people have problems? What do we know about their experiences? The second thing is knowledge about whether interventions work. So Navi gave us an incredibly beautiful list of 8 things that we could do. What are interventions that work, that make that happen? And we know very little about that. Does the intervention of setting up a tribunal work? Does the intervention of training judges on a particular issue work? Does the intervention of training a bar association work? And this is the kind of stuff we've been doing over the last 60, 70 years in the justice sector. And if contributions by donors are anything to go by, they don't think it works. because expenditures on justice and rule of law, have gone down, up to, a decrease of 40% in the last 4 years. So it's very clear. When I talk to DFID, when I talk to many similar types of organizations, they're not sure whether it works and whether our interventions, are achieving anything. So if we, as a justice sector, and that includes ICL, if we want to, make the case that something has to happen, we have to show that what we do works, or at the very least that it doesn't work and that we're thinking of something else that does work, and be very rigorous about that. In the area of ICL, I don't follow that very closely anymore, but I remember a while ago reading a randomized control trial, an article about a randomized control trial that had been done in Sierra Leone on a particular method of truth and reconciliation that had been done in a couple of villages. And that was the first time I read an article where they had a particular intervention, this type of TRC, and they measured what it did, and then 2 years later they measured what had happened. And actually the conclusion of the article was, in some respects what we did worked, in some respects it didn't, and this is where we need to improve. And I know the comparison is not entirely, it's a difficult one to make, but we, I think, should and could be inspired by the health sector in that regard. Health, the health sector, and access to health and cures for medical problems have constantly increased over the last 60 years. Access to health has constantly increased over the last 60 years. Access to justice has not. And I think this is part of the problem. We don't know what we're doing. And as lawyers, we're too much tied to our legal concepts. I didn't get any empirical stuff, and I have a PhD in law. I had all I was taught was concepts and beliefs, and I think in the age of today, that's really not enough. And the last thing I would probably say is that, and this is for me a very important recommendation that was made in the task force report. And Navi, I'd like to refer to something you said as well, just the issue of prevention. In our justice world, we only look at, the cure when somebody is really sick, but so that's courts and lawyers. But we don't have prevention. If I ask, and I've done that jokingly, who's responsible for preventing divorces in a particular country? Who's responsible for preventing that poor people end up in a big mess as a result of debt problems? Where's the prevention side? And if you ask a Minister of Justice, he says, no, I'm not responsible for prevention. I just build courts and I make sure there's a legal aid system. And when people come with a problem, they come to me, and that's my job. So then you ask the Minister of Social Affairs, who does that? He said, no, I just, I give social aid and so on, but I don't really do that. And it's only very recently in the Netherlands that we had this group come together to look at the issue of debt problems. So we had gobs of people, and I've seen that also in the United States, where people end up in jail and a lot of horrible things happen to them as a result of a $100 debt they once had. And that has yielded some really interesting thinking about prevention. How do you avoid that from happening? And I think that's a paradigm we somehow also, as part of the SDGs, need to happen. And then the prevention is at different levels. Navi, you spoke of ICL to prevent wars, which I think is one of the steps. I would even go further. What could you do to prevent that you even need to invoke ICL? So there's lots of layers, I think, in the prevention question that we should be thinking about. Some of those are in the Pathways for Peace report, and they need, I think, serious attention. Thank you.
Thank you, Sam. Yes, indeed, what you said about measuring justice, also measuring the rule of law, was a very important topic during the negotiations, because a lot of the opponents, those who didn't want to see SDG 16 or access to justice, rule of law in the agenda, were saying that this is pointless because it cannot be measured. So that was, and still is, a topic that needs to be defended, that indeed there are ways to measure it somehow. Now, would you like to add something to the issue of implementation and measuring of the SDGs?
Thanks, Nora. You know, I'm not big on measurements, and because my experience, especially working in the area of conflict and transitional justice, sorry, Sam, about fielding, but we focus on certain issues, has been that it's very easy to, you know, have the indicators. Like, for example, this measurement on SDG 16. I mean, we have in there issues around ensuring the strengthening of institutions, ensuring responsible, inclusive, participatory, and representative decision-making. This is not new. These are, you know, standards and indicators that have been set for many other existing instruments, but they have been put here in this SDG as, you know, an indicator for measuring success and, you know, progress. I want to say that, in my view, citizen participation should be at the center of ensuring that we are making progress. And by citizen participation, I mean even the most excluded members of that society, of that country, need to be involved in this collaboration with state bodies in terms of ensuring that this strengthening and this implementation of the SDGs is happening. On the question of data, I agree with Sam that it's terribly important, but it's also very difficult where the national institutions that collect data, I don't know what they are called, but in my own country, they're like the Bureau of Statistics that are responsible for collecting data, are unable to do their job very well because, for starters, they don't even know how many people are in the country. So that becomes, you know, a little problematic. So you'll have data coming out of the education sector, you'll have data coming out of the health sector, you'll have data coming out of the areas in which development assistance has been provided, and it's somebody else paying for that data. So it becomes really there's no ownership, which is, you know, also central to the SDG agenda. There has to be national ownership of implementation. So, and that has come up as a challenge. Every time there's this national review, it's always that we can't collect data, we can't segregate the data, we need more resources to collect the data, and so on. I think I've seen that in almost every report that I've seen. I wanted to say that in terms of implementation, some of the challenges that we are seeing, and I'm going to give the example of a country that has been held up as a model of the observance of democracy and human rights, and this country is Benin, which is a small country in Africa. Right now, as we're sitting here in Nuremberg, Benin is undergoing horrific post-election violence. This is a country which has been reporting, having national reviews on this SDGs and has come out looking quite good. But what has recently happened is, I think last week they had election, there was major reversals in terms of their ability to compete for political office. The current ruling party had made it impossible for other parties to compete. And therefore, all the progress that had been made is now in reversal. As we just sit here, soldiers are shooting people in the streets. The demonstrators have been arrested arbitrarily. They've been put in detention. The demonstrators have burnt a big, huge, one of the largest cotton factories that sets back livelihoods, sets back the economy, sets back all the progress that it made in terms of, reducing poverty and so on. And so this is just an example about how reversals happen. Just because there was, a new elections law that reversed decades of progress that had been made. And so I think in terms of thinking about implementing and recording progress on SDGs, we also at the same time have to think about those factors that, trigger these reversals that we are seeing. So it's not, I wouldn't say it's on a straight line trajectory. It's you win some and you suddenly lose quite a lot.
Just responding or reacting to some of your thoughts, Betty. It's so true what you say. So data has a big risk of becoming a checkbox, which it shouldn't be. It should really be a way of working. And I sometimes go back to the first, I believe this was in the UK, it was the first doctor in the UK who basically said, well, we're all kind of doing intuitively what we're doing, but shall we measure? Shall we adopt an evidence-based way of working? And he was the most, or the least popular doctor in the UK for quite a few decades. Because he was actually, trying to find out whether what his colleagues were doing and the kind of interventions they learned about were actually working. And it took a couple of decades. And there was a second revolution in the medical sector only in the 1990s about, evidence-based working in hospitals. So it's not something you just do overnight. And it will take a lot. And in many ways, I think it's something that needs to start also in law schools. Luckily, you're now starting to see law schools that are teaching lawyers about data analysis, social science research, and to me that is absolutely critical that happens. And these political things are I've got quite some experience with that. We did a big nationwide justice needs survey in Kenya a few years ago, and we had very, very interesting discussions with the National Bureau of Statistics, for example, on the sample size, and the National Bureau of Statistics was under a lot of pressure about you do not choose based on tribes, which regions, and it was all very, very careful. It was a really difficult discussion, but we managed to find a way out. I've also got quite a lot of scars of knives and bullet holes in my back from sessions that we've held with chairs of presidents of the National Judiciary, bar associations, whatever, when we were presenting preliminary results of our data. And they, many of them don't like to hear that 2/3 of their citizens are actually not very happy with what they're doing, or that, as in one particular country, more than 70% of the women involved in separation procedures encounter very serious violence. So it requires tough decisions and tough discussions that you have. And maybe I could share an example of something that we think kind of works, which we've learned, and it would be interesting to see how, whether there are any reflection on that in the room or something to take forward. But that was in Mali. So in Mali, we did our second nationwide study on justice needs, and it was published only 3 weeks ago. I was there, and we did that in the form of a really interesting collaboration right from the start. So it took us a year to do the whole survey and to do the analysis. And the Minister of Justice formed what he called a commission technique around us. So we were not doing the survey. We were doing the survey with representatives from the Bureau of Strategy and Planning from the Ministry of Justice, somebody from the Bar Association, people from the Judiciary, the National Bureau of Statistics, and a bunch of others. And together, we designed, I mean, of course, using our methodology, but they were able to add questions. They were part of the process, and civil society was also on the table. And we designed it together. They were very much involved in the implementation. They got the initial results. They worked with us to interpret the results. So it wasn't like we were preparing, a data report like a scorecard and tossing it over the fence and saying this is not working. It was really part of something we all did. And when we launched that three weeks ago, the Minister of Justice was actually quite proud in saying, this is an étude nationale that we've all done. These are the voices of the citizens, le voix des citoyens malignans. They've spoken to us, and this is what we need to work on. And in fact, it created a very positive attitude of something that we can now do, something we understand better, something, regions where we could do certain things. And the last thing we've really learned to do is when we do this kind of data collection is that we don't only show what doesn't work, but we also show what works, and what might be scaled up. So one of the things in Mali was that in some regions, the chefs de village were actually really good in solving land problems. And that's something that could then be scaled up, and we could try and find out why is it working so well there? Why is it not working elsewhere? And detailed, interesting finding, but in some regions, the police was considered extremely useful in marriage and separation issues, which is not their task at all, but it's working. So, there's also a lot of room in these kind of studies to put good news out there. And then it becomes not just data and outcomes in the scorecard, but it becomes a way you're all working to face challenges and to resolve things.
Thank you. Indeed, so localized measuring tools and indicators are very, very important in supporting the universal indicator framework. I recall with the drafting of indicators by the UN interagency expert group that it was intended really to be this technical exercise, but in fact it soon did become more of a political one, there being pressure from different sides to include certain indicators and not others. And I'm not meaning only states or non-state actors, but within the United Nations themselves. For example, UNODC wanting to push for an indicator on detention for target 16.3, because that is the field, again, a field they are working on. So it's, while it is universal and intended to be sort of technical coverage of how to measure SDGs, there are these underlying other political currents there as well. Now, from measuring to reviewing, while the SDG 16 has not yet been a priority area in the voluntary national reviews, some references have been made to it or to the broader subject area of human rights, justice, access to justice, institutions, and so on. What have been the lessons learned from experiences so far in different states based on the VNRs or other reviewing tools within the SDG system?
I can start. I think, I don't know whether it's a lesson learned or just the reality of the situation, is that the focus on human rights and international criminal law is very discomforting for a lot of states. In particular, the 40 or so states where there is, some conflict, and certainly in the many states, in the quite considerable number of states where there is active civil war or armed conflict. What we have seen, and this has not been reported on, I don't think it has come in any reviews, except of course in Kenya's, I think I saw in the Kenya report, they had reported that they've been facilitating peace negotiations where agreements on establishing accountability mechanisms which promote human rights have been included. But suddenly there has been very little advancement of the course of international criminal law. In fact, there has been a reversal. And right now, some of the conversations we're having, certainly on the African continent and the Africa Union, would be around the place of international criminal justice in the development of our own legal frameworks for accountability. So that you're seeing that there's very little exercise of universal jurisdiction, and this is not just on the continent of Africa, but I think even globally you are seeing some reversals in terms of the reduction on the exercise of universal jurisdiction. I think that's something that we can think about in terms of assessing the implementation of this SDG 16, how to expand and how to ensure that international criminal law develops in the manner that was intended. I think some of the advances we've seen is an improvement in promoting public access to information. I think even in, we've seen in many countries the development of standards around and laws, national laws around access to information, and this becomes important in ensuring that one is able to measure, progress on that SDG. The strengthening, I think, of national human rights institutions is, has to be counted as one of the other important aspects in terms of advancing this implementation of that particular SDG. I want to go back to something Sam talked about, not just measuring data, but thinking about outcomes. One of the aspects that has come out in this latest report by the Task Force on Justice is the justice gap. They've highlighted how many people really don't have access to formal justice. But one of the issues that I think still needs some debate is what justice, for which people? Justice, for example, for women who have been victims of sexual violence in conflict, justice for those children in Ghana who have been enslaved, justice for the increasingly more vulnerable migrants. Their idea of justice is entirely different from the idea of justice that we think about when we think about SDG 16, because we're thinking about, advancing international criminal law. But these people that I've spoken about, these people who have suffered enormous violations and exclusions, the idea of justice may be entirely different. And this is, I think, something that we can begin to think about in deepening and broadening participation of the most excluded in terms of really making the SDGs mean something to the people that they are supposed to affect.
What are we learning? I mean, when I go through the Sustainable Development Goals report on what we're doing, my general impression, especially in regards to SDG 16, but some of the others as well, is that we don't seem to be doing so well in reaching them. And that knowing what we know and knowing what we don't know isn't very well developed. The indicators are you know, a bit all over the place. Some of them are, you know, very high level, some of them are very practical, and that also has to do with the different topics. When I relate it to our field of justice, I really think we as you've said, Betty, we have to start thinking about indicators. If you have a review mechanism, you need to review it against something, and then you need some form of indicators, like it or not. And they have to, I think, be outcome-based primarily. Too many indicators that we have out there are output-based. And, you know, output is great. It's nice to know you've set up a tribunal. It's nice to know you have a court in every region of your country. It's nice to know that you have so many lawyers per square meter, but are they delivering more justice to more people? And I know that's an easy question, you know, to ask, and it's a hard one to measure. But we have to measure that, because otherwise, I don't think our profession, you know, can be taken seriously, and frankly, I don't think we'll survive in the competition for funding. So, you know, we've got to think about what are the outcomes for rule of law that we want. You know, rule of law should contribute to less violence, you know, at a broad level, which is one of the SDGs. It should somehow support economic development. It should somehow create or help build more social cohesion, participation. These are all kind of things that rule of law is supposed to somehow make work. And then the SDG, and we were very closely involved in the data that we, you know, putting together this justice gap for the Justice Task Force. And there are some numbers in the report. You know, 5.1 billion people do not have access to justice in the world. 250 million of those live in extreme situations of injustice. So these are, you know, stateless people, 25 million people working under forced labor. 1.5 billion people have justice problems they can't solve in the area of crime, employment, family, land, neighbor, consumer disputes. And about 4.5 billion people are excluded from social, economic, and political opportunities. They have no legal identity. They have, you know, insecure employment relations that have no legal basis. So that's pretty big. But what you need to do is go much more granular. Really go into, so what does this mean? And behind these figures, there is a really interesting paper of what underlies that, and what I always find because I'm not a measurer, but when I talk to, you know, measure specialists, and all the discussions I've had over the last years in developing these outcomes, people that measure, data analysts, they know better than anybody else what they're not measuring and the limits of their measuring. It's usually us who don't know exactly what it is, or journalists who turn something that is, you know, about 80% correct into the truth. So there's a lot of discussion that we still need to have on that. And another thing that we don't really know is you can collect all the data in the world, and the OECD is a great example of that. They've really now moved into the access to justice field, and the other day I was talking to one of their director generals who collects a lot of this data. But what we don't really know yet, and I'm still a bit pessimistic about that, is if you have lots of data, and it's really good data, that doesn't mean that you have policymakers who actually know how to work with that data and how to turn that data into a strategy and how to build an iterative program. So most of the donors that we work with still ask us to write a program that will basically tell them what we're going to be doing when for the next 3 years against how many hours, which is ridiculous if you think about it, because, you know, there must be a way that you could develop programs in a much more iterative way. Where you say, yeah, that's where we want to be. We're going to try this. We're going to see if it works. We're going to iterate. Then we're going to do it again. And together with the donor, we're going to try and see if we can achieve the goal. So there's still also a lot of work that needs to be done. And I have met very few ministers of justice or chief justices or chief prosecutors that could actually turn data into an evidence-based way of working, into making a strategy that would allow them to, adapt as they go, learn as they go, and be more effective. And I'll give you one little example from Mali, where we've been working for quite a while. In 2014, we did our first survey there. It's a bit of a nasty example to give, but let me give it anyway. So in our Mali survey of 2014, we worked very closely with the Minister of Truth and Reconciliation and whatever. She was a very impressive woman. And with her, we included about 40 questions about truth and reconciliation in our survey, which was on a lot of other issues as well. And what came out of that survey was some really interesting stuff. First of all, we had questions that they had asked us to put in on, do you want truth? Do you want justice? How do you want your compensation? Do you want the trust fund? Do you want money? Do you want all these very practical things? First of all, what came out of this study very clearly is that there were huge regional differences in Mali. What people wanted in the north was not the same as what they wanted in the south. The second thing that I found very interesting is that people who lived closest to the conflict were much more asking for truth and a lot less for trials. And people that were further away wanted trials and punishment. More, slightly more. There was a difference. But especially the regional, and there were also very big differences in the way that people wanted compensation. And that made a big difference. Do you want your compensation given to you in kind, or do you want it to be given to the tribal leader who gives it to you, or do you want to receive it yourself? And there were big differences between urban and rural there, for example. We sent all this stuff to the ICC. We never even got a thank you, and I don't think there was no evidence anywhere that it was ever used. We just did it again, and it's very interesting. 2018, same kind of questions and the same kind of replies. Regional differences, the same nuances about truth and justice, the same differences in how people want their compensation to be had. I'm going to send it to the ICC again, but there doesn't seem to be a dialogue. And it's not about bashing the ICC, but it's a typical thing. We just don't have that way of thinking and working, and we should develop that. And not see this kind of data as a blame game, as something that is annoying, as a scorecard, but as something that could make us more effective and work better.
Thank you. That's a perfect bridge to one of the, not the final question, but one of the final questions to the panelists regarding the local and global justice. Given that both the title of the SDG 16 and the wording of Target 16.3 address access to justice, how do you see access to justice extending from the national level to the international level? What does access to justice hold for international law? I mean, this is somewhat of a conceptual question, but I think it's important to consider also the operative elements of that. Do you want to go first, Betty?
We only have 3 more minutes, which is good. I really just wanted to follow up on and I think it segs into your own question. I wanted to follow up on some of Sam's comments in terms of, what do people perceive as justice? I mean, through many years of working with victims of sexual violence in conflict, their idea, one of the areas they prioritize in the justice spectrum is non-repetition and structural change. So they would say it's good, if you have trials and so on, but what we would like to see is this never to happen again. And so how do we get to making sure that this doesn't happen again? So whilst they're prioritizing the reparatory measures of non-repetition, they're saying that they are also interested in ensuring that they themselves get an opportunity to be engaged in the articulation of what this looks like. And what this looks like is ensuring that the structures that enabled the violations to take place in the first place do not exist for these types of violations to continue to happen. So whilst they say it is important that there is accountability, what is more important is that they, through this process of accessing justice, that they participate in designing measures that ensure non-repetition, designing measures for reparations, for example, ensuring implementation of new laws that change the way the situation that enabled the violations to take place, it does not happen again, and so on. So that becomes really important. So before we escalate it to now the international level, I think that to the international level, the national level access issues is more important. And it will continue to be more important for as long as we are not doing enough prevention, for as long as states are not protecting their own citizens, for as long as we're thinking about justice in this very limited way, that justice is access to courts and access to criminal justice institutions and access to international tribunals and international justice mechanisms. Unfortunately, we have seen failures and disappointments. We have experienced failures and disappointments, and with a lot of apologies to my colleagues with whom I have worked for 20 years just to ensure that we have an effective and universal international criminal court, we have seen that that has not delivered on all its initial promises. And so therefore, I would rather focus my own attention and attention of the communities, and this is what I've seen, the attention of the communities with which I work, focused on ensuring that local justice response, local justice mechanisms response to their own justice needs. I think understanding what are the justice needs becomes critically important.
Yeah, I would very much echo that. I mean, one of the more impressive books that I've read over the last years is Ordinary Virtues by Michael Ignatieff, and he kind of went to look for human rights, where are they, and traveled all over the world, and yeah, the title Ordinary Virtues says it all. I mean, you know, he basically says where human rights happen is in neighborhoods, is in the streets, very close to home, and that's where it really happens, and that's where it really means something for people. I think that's very true. And there are things that we we do know, like what is justice? Well, there's from psychology and neurology and etc. We have figured out a number of factors that are important for a procedure to be perceived as justice. People want to be heard, people don't want it to last too long, people want to be respected, people want to understand the procedure, so we know pretty much that if people understand the procedure and it didn't take too long and they felt heard and they lost the case, they're fine with it, generally speaking. But if none of that happened and they lose the case, they're not fine with it, and the perceptions of justice change considerably. So these are things that I think you can really work on. And on the more macro level, what I've again seen with you know, and what's emerging at least in my mind as a best practice to work on national justice strategies and more at the governmental level, whether it's local government or whatever, is that, you know, what you first do is you collect lots of data about the lives of citizens in many ways. And then you come back to your point, Betty, of participation. So you bring lots of people together to look at that data. And it should be people from those communities, mostly, who interpreted that data, who try and understand what is this data telling us, and who can on that basis then decide what are the problems here, what is not working, and how do we define that, and what, based on our data, would be an improvement. And once you have that clear, only then could you start thinking about strategies and all this other stuff, because then it becomes fairly easy. If you know what the problem is, and you know what the improvement is, for example, you want to make sure that people feel more heard, or you want to reduce violence in a particular part of your country, you can then bring together all the actors that matter to solve that problem. And indeed, some of the solutions, courts can contribute something to the reduction of violence. Police can contribute something else. And then you can start constructing a pact with all the different contributors to the resolution of that problem. And you lock that in, with indicators and in some kind of close collaboration process, and then you're really solving something. And then you also avoid all this, what you frequently have in sectional collaboration, turf wars and whatever, because everybody, and that's the ideal situation, contributes from their strength to solving that particular aspect of this big problem that we're trying to solve. And I often, say, I don't think citizens care about the separation of power, or I don't think they care about independent judiciary, which is, of course, what we always care about. They generally care about the fact that they were fired and they have no recourse, that they were beaten and they have nowhere to go, that they lived in a house they can no longer live in. And of course, independence of judiciary, separation of powers are best practices to try and solve that, but that's what they are. The outcomes really matter, and we have to think about how what we do contributes to those outcomes. Thank you. Oh, yeah.
Thank you. So I have one very brief, well, I hope the answers will be brief as well, question to end with. So a broad question that I hope will guide the discussions during the next 2 days. What are the most important elements of the SDGs for the advancement in the fields of human rights and international criminal law?
I think one of the first ones that Navi pointed out, which is prevention of violence.
Yeah, all I can say is, wow, it's a bit of an overwhelming question. Could you ask it again? What are?
Sure. So, what are the most important, or the most important element of the SDGs for the advancement of human rights and international criminal law or criminal justice?
You see, that's why I'm confused. Something that happens to me when I hear this is it's almost like the SDGs need to contribute to ICL and human rights, and for me, it's the other way around. It's what can we contribute to those SDGs? Again, what can we contribute to prevention of violence, more water, better education, these climate change? That's, I think, our task. If we look at the SDGs as interrelated as they are, then our task is, okay, what can we do to reduce violence? And violence means something different in every country, in every setting, and we can have data on that. And that should be what we should be judged by. What we can contribute to those outcome indicators that matter in the lives of people, and nothing else.
Great, thank you very much. So now I open the floor to questions and comments, and I would like to remind you to stick with the 3-minute rule. So do not ask any longer question than that. Thank you.
Thank you very much, and I'm reminded to raise up. I don't know why. I'm taller than anyone in seating already, so thanks to the whole panel for a great discussion, quite inspiring, but it also gives a little bit of a sad feeling. Seems to be a big gap between the glorious New York UNGA hall where they adopt the SDGs and then the mundane reality on the ground, which you have talked about, which is actually what you try to measure, and where the work is done. From my point of view, how can we bridge that gap? How can we make sure that the mundane results of your measurements, the mundane activities that we plan, actually tied back and linked to the quite abstract UN SDGs?
Okay, that's a big question, Klaus. The first thing comes to mind is just a lot of hard work. I think part of the answer is also something Betty mentioned, the importance of regional organizations, and beyond that, strengthening, national capacity. And I just keep going back to, data. Data on outcomes, and learning to work with data. That's really the only way you can do that. And I don't believe there is, because that's what we often do, especially with these great international declarations. We think that is a magic bullet, and we think that when we've pronounced it, then all will be well. But stop believing that, because it's the ordinary virtues. It happens on the village squares, in the neighborhoods, in the families. That's where ultimately it's gotta happen. So that's the granular level that we somehow need to reach. And it means for ICL that we really have to open up. We cannot be, this legal field that works mainly in capitals and is very, very conceptually based, very much based on beliefs of what we think should be justice, without asking the communities whether it's what they want, whether it's what they need, whether it works. Again, a concrete example, we are now working with, we did a big survey on justice needs among Syrian refugees in Lebanon and Jordan last year, and we asked them about their justice needs, and guess what? Putting Assad on the ICC does not feature on their justice need number 1. It doesn't feature on 2, it doesn't feature on 3, it comes somewhere on 8. What features first is, I want to go back to my house, and I don't know how to do that. I have, family members that have died. I don't know how to deal with that. Or there's a lot of inheritance issues, divorce issues, children that have no identity documents. I want access to public services, these kind of things. And that is not something that the international community is looking at. It's looking at the accountability thing. It's not to say the accountability thing is not important, but again, it shows the disconnect, at least at the moment, between what some of the surveys show, and they're not the truth, but and some things that we think people need. And in the Syrian conflict specifically, I've talked to many Syrians who say, I don't think we're being listened to. We're being involved, but we're not being listened to. The West kind of knows what our problems are, and they tell us. So that has to change.
Yes, and I would like to add to that that we should keep in mind that the 2030 agenda states itself that it is an aspirational document to guide the actions for the next years to come. So even if it seems that there is this huge gap, at the one end you have the ideal situation, so to say, that hopefully can be worked towards. Now,
can I just say
yes.
a bit thing about that, about the aspirational thing? I was reminded of something, and I didn't really get to say that. So I remember discussions I had many years ago with a great legal scholar from the United States, Brian Tamanaha. You may know him, and he's written some great books about rule of law. And when he tried to figure out what's the origin of rule of law, and he has this wonderful image of, rule of law really started out in small communities, and they had the big question of, Navi, you gave us a definition, but I'll do this question, who will lead us? And they needed a king to lead them. And he said that he looked at it, but in almost every single culture, they had kind of a ceremony of anointing a king or a queen. With either pour water or oil or something happened to anoint the king. And if the king would accept his or her role, he would almost in every single culture say, thank you for giving me this role, I promise. And he would promise some things. And it would also be variations of the theme, I promise to take care of you. And by saying that publicly before everybody, before God in most cases, there was something that those people could invoke. So when he didn't take care of them, he could say, hey, hang on a minute, we crowned you, and you stood before us and before God, and we anointed you, whatever, and you promised to take care of us, and you're not doing it, so now we're going to invoke that. And this process of invoking slowly built the wonderful definition, Navi, that you shared with us. And I like to think of the SDGs a bit like that. Let's invoke them. I mean, aspirational or not, I don't care. These are incredibly good targets. They're very clear. And you know, what the legal depth of them is or not, I don't really care. But it's for us, as a justice community and other communities, to just keep invoking them, because 195 states got together and said this has to happen. And if we can just hold them to that and just keep invoking that, and I think that's what we need to do.
Let me now collect 3 questions, so we'll be a little bit more time concerning. Yes, we have 2 here at the front, and then I think we had 1 at the back.
Yeah, good morning, Philip Ammer from the ICC. Thanks a lot for that starting panel, which I think was extremely elucidating. I'm very much interested in this entire performance indicator discussion, and exactly what Sam said, that, just to repeat it, that we're looking at outcome-based indicators as opposed to output-based indicators. I'm saying that because at the ICC we did something similar. We tried to come up with indicators, and we had the big discussion, quality versus quantity, or quality versus workload, which adds a little bit to the exact same problem, that you can easily measure workload, but it doesn't tell you anything about how good it actually is, what you're doing, right? Then when we had the discussion as to, okay, what quality indicators could we have, we actually got into serious trouble. What's the quality of a judgment, and who measures it? What's the quality of, say, the conviction, or what is the quality content of a conviction rate? And this is where you're getting into the discussion of, well, the rule of law could also be an acquittal. And then we got to the point of, how about measuring how the stakeholders of such a court, the victims, see the justice system as functioning. So is justice being seen as being done? And this is where I'm picking up another point that Sam made in terms of the question of truth versus justice. Do we really ask victims what exactly they're looking for and what exactly they're expecting to receive? And if we miss out on that, can the data that we would potentially get be decisive for anything at all? So basically, I'm detecting a dilemma here that we might be looking at these indicators that you're referring to from an angle that is basically just our understanding, but not the understanding from those that, if you wanted to measure quality, would be informing you about that. And then that leads me to my question, who's going to measure this then? Who's going to define what is relevant, and who's going to measure it? And I'm now remembering that, and I'm asking this because much of the thinking behind the UN agenda is that states are called upon to actually clean up their own territory. If you look at who's supposed to be providing the yearly results, it's states. Now, if I'm a state and I want to look good, then obviously I will define what I measure, and I'll make sure that I look good. So how do we regulate that bit? Thank you.
Yeah. Thanks. I really appreciated Betty's remarks about getting input from local communities when we're talking about justice. But one of the issues, I think, is the economic element. So, for example, if reparations is high on the agenda, and the resources are not in that local community, how do you address that point? And ultimately, the economic issues are very important in terms of delivering justice on the local level. Now, if the SDGs are primarily focused on delivering justice in the kind of general sense, but we don't provide the resources, and there's no track to make the kind of investments to do justice, whether it's reparations or more broadly, or address economic justice issues in those communities, How can we make the SDGs effective? How does SDG 16 work without that input? And I think that's a pretty big hole that we really haven't discussed yet. And it's something that is in the architecture and I don't know that's been addressed. Thank you.
Thank you. And we had one question at the back.
Thank you. Just a comment regarding the data mining concerns we have and the universal periodic review you mentioned, Nora. There is a study of the Danish Institute of Human Rights where they, through a data mining process, they realized that almost 9,000 recommendations during the 2 last cycles of the UPR, they are linked directly to the SDG 16. So in total, there are 50,000 recommendations, so it's a great majority regarding justice, peace, and institutions. And especially the majority of recommendations were about rule of law, national human rights institutions, and fundamental freedoms. So this is more a comment than a question, but maybe the challenge is regarding not new data mining procedures or more resources, but policy coherence, policy efficiency, will, and accountability through human rights approach or approaches to the SDGs. Thank you.
Thank you. Betty, would you take the floor first?
Okay.
Thank you.
I think I just had sort of one comment and question. Thank you, David, for those comments. I think on the question of community participation, I mean, there are various innovative approaches that I think have been adopted, across the globe. But I think I'll give you an example of 2 that I'm aware of. One relates to formal justice, and one relates to, broad justice. In Kenya, which has now adopted a decentralized administrative structure, so that instead of having just a central government, there are now 47 county governments. Now, in those 47 county governments, again, counting numbers of courts and so on, there is a formal justice system with a court in each county. Now, for each court system, there is what has been developed called the court users committees. Now, the court users committees have within their own membership ordinary, the market women, the fishermen association, the chief, because chiefs are important in some parts of the world, the local administration, the police, who then become very important, the judiciary officials, who are the least in these court users committees. And these court users committees come together and have sittings once every month and decide what are the priorities that they would like the entire criminal justice system to look at within their communities. And they also, have input in how, what kind of costs are being charged by this court. So, for example, because of court users committees, now if one wants to file an administration a case for inheritance or something like that, you don't have to pay money for that. If it is a case of pursuing an injury by wildlife or by, a motor vehicle, and you need a police report before you can initiate the case, again, then you don't pay for that form. Because before, it was a huge expense which ordinary people could not afford, and therefore they never made any claim. So that's, one way of, getting the communities to participate. But clearly, I think what is even more important is the development of and the capacity, the increasing the ability of people to participate by ensuring that they have the correct information, that they have access to information about what their rights are. So obviously ensuring that civil society is able to function at every level. Now with the new laws that are coming up alongside SDGs, laws that are also limiting civic participation, that's also holding back the ability of communities to participate. Another example is from Liberia, which is the Palava huts, where, you know, they sit wherever they sit and they discuss all the issues that are important to them, and these then therefore come to the administrators. And the administrators here would also be the local justice mechanisms, which are the chiefs, barazas, which are the traditional courts, which hear 85% of the disputes in some of these countries. So I think, you know, those are two examples. On your comment about, you know, how do you ensure that, you know, the economic, you know, delivers justice. I think investments must be made, and investments must be made at all levels, in social protection, in ensuring that people have the means to participate. And so, I mean, that's what I can say. And I think at the national level, again, just going back to the review reports, these investments have to be made at the national level.
Yeah, very briefly, Philip, when I was involved right from the start with the developing of the Rule of Law Index of the World Justice Project, and when we started that, you know, I frankly felt that it would never work. But I thought, you know, this is an adventurous road to nowhere, so let me join that, and it worked. And I think what is the key with measuring such indicators, and you can think some of the same, you know, the Global Peace Index. I never thought you could measure peace. And what we actually now have is a fairly global, fairly good, robust GPI. And the trick of it is that it, you know, the Rule of Law Index took 5 years almost to have, you know, a version. And it's a bit like developing an IT tool. You develop a beta version, you test it out, you develop a next version, you test it out, and you keep going. And the Rule of Law Index and the GPI Index keep improving all the time. So you're never there. It's not something that you develop and then you implement. It's lots of work. And secondly, you asked who measures. You know, I think we should look at the health sector. The strength of the health sector is everybody measures all the time. And that's how you get to truth. There's not one measurer who does everything. You can actually compare a study done by a particular university there to another there, and that's how you kind of understand where you need to go. It's true that the SDG agenda says states measure, and I didn't like that. I was pushing for something else, but on the other hand, I don't really mind, because nobody could stop me from doing what I do. So, you know, Kenya has its official measuring, but we did a nationwide survey there, and we did a nationwide survey in Nigeria, and we're doing one in Ethiopia, whatever. So, I mean, there's so much room that we as civil society think tanks can find to measure, and if states come up with data that's completely ridiculous, we can show that it's ridiculous and deal with it that way. David, I think you're right. This economic thing is absolutely critical in the whole thing. It's also something we devote a lot of time to in the task force report. It's the first time ever that we've tried to understand how much does it cost to provide universal basic health care to everybody. That's never been done. It's been done in the health sector, education, and it turns out that in low-income countries it's about $20. And from there we could work out what's the tax base in these countries, and we find out that in the countries where justice is most needed, the tax base is by no means enough to deliver $20. But that's something then we can work with. A second thing that our surveys show, that the willingness to pay is within a certain bandwidth, seldom a showstopper for people when it comes to justice. Within a certain bandwidth. People are willing to pay. What's much more of an issue with most customers of justice systems is that they don't know where to go. They don't know they have a justice problem. If they pay, they don't know where it'll end, how long it will take, and whether they'll get a result. So there's a lot of stuff that we could do there. And the last thing I would say is, and that's also one of the key recommendations to deal with this very important issue, is the field needs to open up, because repeated economic analysis has shown that law firms as your principal business model for providing justice is very ineffective. It's a bad investment. They actually spend, Gillian Hadfield worked that out, you give $250 to a lawyer an hour, only 80% of that, or $80 of that is spent on giving justice. The rest is spent on marketing, bar membership, I don't know, lots of other stuff. And that's been repeated elsewhere. So I think the sector needs to open up, because it is absolutely clear to me, and we give an annual innovation award, evidence-based, there are providers out there that have business models that could actually provide something at a much better price than the more traditional models that we have. And so the justice market, just like the health sector, needs to open up and have all different types of providers that could provide services. And that, at the moment, is one of the big showstoppers for change, because the markets are closed, they're heavily regulated. We had a really interesting session on that last, a few days ago at the World Justice Project to see how that could be opened up.
Thank you. So we are running out of time, but we have just about time for one very brief question or comment.
My name is Katie Hirschminder. I'm a assistant professor at Maastricht University and do a lot of research with refugees and migrants. I've heard frequently in my field that there's a large claim that we need more data on refugees and migrants. Yet at the same time, I believe we have a lot, and I'm currently working with researchers at other institutes in Lebanon who tell me we don't want to do the survey of Syrian refugees because it's unethical, too many surveys have been done, and nothing's changing. So my core question is, how do we make the data that we have, which is quite a lot, actually count? And how can it count in your field to actually create change?
Great, thank you. Sam. So, to you, Sam.
I guess my answer would be a little bit of a pessimistic note. That's the problem. I don't think, we're starting to learn a little bit about data, but only a little bit. And translating data in the justice sector into policies that work, into interventions that we try out, learn from them, that's not what we're very good at. And that's not what ministries of justice are equipped for. That's not what chief justices know how to do. And that's a large part, at least what our work is, in helping with that. And we have to learn to do that. So I'm afraid I don't have a magic bullet for that.
Thank you very much. So thank you for the speakers for the intriguing opening dialogue, and I think there were many fascinating ideas and proposals that will surely be taken up by the ensuing panels. Also, thank you for the audience for your attention, and I wish a fruitful conference. Thank you.